Thank you. Welcome back to the Law News Network, folks. I'm Aaron Keller here along with Josh Povill, who is a guest we have not seen recently here on Law News. Josh, good to see you again.
Thanks a lot, Aaron. It's good to be back.
We're talking about this case in Florida. The facts are just disturbing because it's a mountain of circumstantial evidence, but there isn't any really clear-cut direct evidence. We don't have bodies. We don't have a lot of things that we would normally see in a case, and the defense, of course, has played that up.
Yes, it seems we were just listening to the defense's opening statement, and it seems they obviously don't have a particular defense to mount at this point, but they are going to mount, it seems, the defense of all defense attorneys, which is you just don't have enough evidence. So trying to wait, bide their time, see where the holes are. They know where the obvious big holes are, like no bodies, but probably wait and see what other holes might pop up and see whether they can find some reasonable doubt in any of those or all of those put together. So,
you've got a defendant, Luis Toledo, who is facing second-degree murder for the death of his wife. She was 28. The two children, her two children, Thalia and Michael Otto, ages 9 and 8, there they have first-degree murder charges. And, you know, it's a big question, a big what if, as to whether or not any of this was premeditated, whether it wasn't premeditated, whether he just snapped, which is what he said to his neighbor, or whether or not this was more planned out as to at least some of the defendants, or excuse me, some of the victims. So a lot of questions there, and I'm wondering, is that something that the prosecutor is just going to have to try to stitch together on closing argument or not? Because they don't have a lot other than the statement of the neighbor who was called in apparently to help clean up in the state's theory. They also have the interviews with the defendant where he said that he had karate chopped his wife's throat in this fit of rage. Okay, so that's why we don't have a first-degree murder charge for the death of the wife. But do we get to first-degree murder on the two kids, or do we not?
You know, I was just looking to try and find the indictment myself and see, it seems that there's all this talk about premeditation, and so I assume that the theory of the first-degree murder charge is that it is a premeditated murder and not one of the other, I think there are two other theories under which you can have first-degree murder in the state of Florida. But assuming it's premeditation, I presume that the prosecution's argument to the jury might sound something like, essentially, even if he didn't intend, he hadn't planned to murder his wife, and he did indeed snap, he certainly, there's no explanation for snapping or losing it on the children. And so it had to result, I think they would argue, from some deliberate plan that he arrived at, either before or probably after having snapped and lost it and killed his wife. But even if it was arrived at afterward, it still might involve enough planning and premeditation to become what under Florida law would be premeditated first-degree murder. And I think that may be what the prosecutors have to argue for them, which is essentially there is no theory under which somebody would just lose it on the children. The only theory would be he killed the children in order to basically eliminate the only witnesses to the crime. That's a crime of planning, that's a crime of thoughtfulness, even if it happened relatively quickly in the circumstances of that day.
The question is whether or not the state has enough to prove it to that level. Do they turn around and say, well, there's this statement that he made that he snapped. It's what he told the neighbor in the car on the way back from this expedition to get rid of some of the evidence, as the state would have us believe. And he also has these statements to police, which are the subject of all the arguments we heard in court yesterday evening, and again a little bit this morning, where the defense is trying to keep some of what the defendant said to investigators out of this proceeding. Yesterday it was an argument to keep all of it out because the state hasn't proven that a crime was committed. This defense is, in at least through half of its mouth, trying to say, well, these three people may have just disappeared, that the wife took the kids and ran off. Despite the evidence and despite that the defendant himself had said to investigators he snapped and karate chopped her throat, and basically, as we're told, admitted to killing his wife, but not the children. Okay, well then where did the children go? The judge threw that request out to keep some, or all I should say, all of the statements to police out yesterday, based on the theory that, well, we don't have bodies, it's not clear that a crime has been committed. Now the new argument today, which led to the jury being sent home, is that parts of those recordings should be kept out. But there's not a lot of information as to exactly who met their end first. Was it Thalia? Was it Michael? Was it Yesenia? We don't know. And to charge first-degree murder for the deaths of the children almost might be backwards in a lot of ways. Because, you know, look, he caught his wife having an affair. He said he, quote, snapped. That's the evidence. So but at what point did he snap? He went to her workplace rather, and confronted her before this whole thing transpired into the late evening. So we're talking about October 22nd, 2013. He shows up at her workplace. The police are called. He takes off before the police get there. She eventually goes home and makes a call to her lover at 1:03 a.m. That's the last the wife was heard from. At 6 a.m., that's when the defendant woke up the neighbor. So, you know, look, they're trying to say that it's not premeditated murder as to the wife because of this statement that he, quote, snapped, okay, at some point shortly after 6 a.m. the following morning of when she's presumed to have been killed. But how does he snap if he shows up to work and puts this spyware on her phone to try to figure out if this affair is really happening? I mean, this is something that is planned out. Is it that he snapped and killed her, or, you know, and an argument could be made the other way with that too.
I could see that. I suspect that the prosecution here felt that making out a first-degree murder charge would be more difficult than it's worth, because there's an obvious defense to it, which is, I didn't plan to kill her, I planned to confront her with her infidelity, and when I did, this argument ensued, and you know, we ended up getting into a fight, and I lost it in a rage, and I killed her. And I take it, even though there had been all this planning for the confrontation, it wasn't planning for a murder, and so wouldn't be premeditated murder in that sense. And that I really don't know what the evidence is with respect to the children to support the premeditation, other than the assumption that if he killed the children, what other theory of murder is there? Which, again, maybe the defense will simply say, that's not evidence. That's not enough evidence. It's any of a number of possibilities could have occurred, that perhaps he simply lost it and killed all of them in this rage, and he just didn't want to admit that he killed the children in the same rage in which he killed his wife. I don't know. And again, he gave an explanation, I believe, for the children's death in his recorded statement. I think he said something about a hatchet, that they'd been killed with some kind of a hatchet or something along those lines. I was reading a report from a while ago about there was a medical examiner who the prosecution wanted to have testify and basically pick apart the entire statement that the defendant had given and show how it's simply not possible what he claimed, or what he claimed was very, very unlikely with respect to both his wife and the children. And the judge ultimately ruled, and this was a few months ago, that huge portions of that testimony would not be relevant, would not come in. They were far too speculative in light of the fact that there are no bodies. We're talking about an examiner who's going to testify about medical evidence that doesn't exist, but he's going to sort of give his medical expert opinion on what the defendant said, claimed to have happened, and whether that is possible. And the judge said that's just too speculative. But it does leave, I guess, the prosecution with the fact that the defendant not only claimed he didn't that he wasn't the one who killed the children, but that he did have an explanation as to what happened to the children. And maybe that simply was, to them, evidence that that when he killed them, it was part of a plan. That if he indeed had killed them as part of this rage, he would have simply said so, as he was already admitting that he killed the wife in the rage. So, as the defense attorney probably just said, the absence of evidence is not evidence. But the prosecution does have a point here, right? In that the absence of any other motive leaves you with the simple, inference that if he did indeed kill the children, that must have been the motive, that he did it as part of this plan to cover it up, basically. So I don't know if it's enough to get you there.
Well, and that's the big what if. I mean, so we can sit here and continue to ponder the possibilities, and the fact that we're pondering is probably proof that there's just not a lot of evidence on the record in this case yet to get all the way there to reach those first-degree murder charges.
Yeah, though I was just reading up on the Florida murder statute, and apparently they've been through a couple iterations recently because of a ruling from the Supreme Court of the United States and then the Supreme Court of Florida. And the upshot is that now, in order to get an actual death penalty, which arguably is the only reason to bring first-degree murder, otherwise you could get the same life imprisonment with another murder charge. But if you want the death penalty, you have to have unanimity from all the jurors voting for death at the penalty phase. My suspicion is if you can get these jurors to believe that he actually killed these children, they'll be so grossly offended by that behavior. I mean, it's heinous beyond anyone's imagination. I think they would have no problem voting for it, but there may be, that big stop sign in the middle, which is, okay, but where's the evidence of the premeditation? I think it's possible, and this is another theory as to why the prosecutors might have brought the first-degree murder charge. The kind of jurors who are qualified in jury selection to render a death penalty verdict are the kind of jurors who are comfortable with the idea of the death penalty. That's the kind of juror who a prosecutor probably feels might be able to move past their hang-ups, if you will, over exactly what caused him to kill the children. And if they simply believe that he killed the children, vote for guilty on the charge. So there are a number of reasons why it might be in there, and I don't know how it'll all shake out when the jury does get this case.
Yeah, I mean, I think many of these questions may be answered once we get to the point where we can hear more or all of these interrogation recordings. So before we get to that, of course, we have to wait for court to reconvene for another day because the judge sent the jury home while the judge tries to sort through some of these issues that we're talking about and determining as a matter of law whether or not the interrogations should be played in full. One of the big issues is whether or not part of the recording where apparently the defendant tries to commit suicide in the bathroom next to the interview room should be submitted to the jury. It leads one to the question, and we were batting this back and forth a little while ago, as to whether or not he sort of thought that he would die as part of this and then chickened out and then thought he'd go through with it and then ultimately either got caught or chickened out again.
Yeah.
We don't know.
I don't know. It is interesting how we were talking about why would he have killed the children? And it was my suspicion, just in trying to spitball ideas, that sometimes these kinds of cases, it's not uncommon to hear that the defendant, who is usually dead at that point, killed his wife, then the children, and himself. This is not a totally uncommon story. We've heard these stories, and that maybe that's what his intent was, originally, and yes, he didn't follow through and actually kill himself, and that when he was caught, he reconsidered, though at that point it's a very different sort of motivation, I take it. He's actually now facing the very real possibility that he's going to spend the rest of his life in prison, and he went into the bathroom and I guess made some attempt to kill himself. What that involved, I don't know. It certainly wasn't successful, but I think the judge is right in ruling that that's relevant evidence. A man who, in the midst of his interview, goes into the bathroom and tries to kill himself. I think a jury should know that. I think that's highly relevant information for them to consider in determining, if nothing else, the credibility and the believability of that statement made by the defendant. They need to know what were the circumstances going on. So, the prosecution
in short,
argues
evidence of guilt.
Yes, a prosecution says it's consciousness of guilt. For all I know, the defense will spin it another way. That this was a deranged, misguided, suicidal man who now was being questioned, and he was in no state of mind to give a reasonable statement. If I were the defense, you got to try anything you can, and that might be how I would try and spin it. But I certainly think the jury's entitled to know it. I don't think it's more prejudicial than probative in this case. So,
well, one of the interesting points that came out very early in testimony in this case is testimony of the victim's mother, the wife's mother, who said, look, my daughter would have never just disappeared with her children. If she were in trouble, she would have come home to me. That, I think, sealed the fate on some of these defense attempts to insinuate that the mother, the wife, took off with the kids knowing that the husband was upset about this affair. She has not been seen or heard from since that day, October 23rd, 2013, where in 2017, almost exactly to the day of when she was last seen, give or take a couple of days, and the mother has heard nothing from her. So let's listen to some of the mother's testimony now.
They call police, Mr. Perez. Yes, sir. Thank you, Your Honor. Good morning, ma'am. You're going to have to turn it to you and speak into it, okay?
Good morning.
Okay. Can you tell us your name, please?
Felicita Perez,
Okay. And, ma'am, in which city do you currently live?
Volusia County,
Okay. And what is your current occupation?
office clerk,
Where do you work?
Lowe's,
Lowe's. The hardware store?
yes.
In which county do you work?
Seminole County,
Tell me a little bit about yourself. How old are you? You married? Talk about your family with me, if you would.
I'm 53 years old. I'm married to a woman in Paris. We've been married for 11 years.
You're going to have to speak up, okay?
I'm 53 years old. I'm married to a woman in Paris. We've been married for 11 years. Like you said, I work at Lowe's Home Improvement. I've been there for 18 years. I'm the mother of 3 beautiful children.
How old are those kids and what are their names?
Yesenia Suarez, my older daughter. She was 28. Jonathan Suarez, now he's 30. Jesse would be 32. And Emily Suarez, she's 28 years old. And I have 7 beautiful grandkids. My 2 oldest one, Talia Otto and Michael Otto. I have my other grandson, Anthony Suarez, Isaiah Suarez, Emmanuel Mejias, Mayrita and Jovi Malaves.
You told us the age difference between your children. What was the age difference, or what is the age difference between your grandchildren?
The first 5 ones, which was Talia, Jocelyn, Their age was between 10 and 12. They all, I had them all.
The first five were
The first
between 10 and
five,
12?
Yeah.
That's a
They-
tight cluster, right?
Yeah. When they made me a grandma, they gave them all, like at once. I remember, I used to say to my grandkids that, what is grandma gonna do when you guys graduate from high school? And I remember Talia always used to say, oh, well, I remember you had to go to my graduation. I said, okay, I hope they're not all the same time. But yeah, I was very happy and very proud grandma of my grandkids.
Let me ask you, where did your children live? Better question. Tell us about the relationship that existed between your children, between Jasenia and her siblings.
Yesenia has always been the older child. She always cared a lot for her siblings, Jonathan and Emily. I was always proud of her. She was like a little child with a big mind. Always wanted to do good on everything that she did. She was a role model for my other children. Always wanted the best for them, encouraged them to go to school, to get good grades, to make mommy proud.
Were they like that from the time that they were small children?
Jessie was always like that. She always wanted to shine, be good, and for me to be proud of her the same way she was doing with her children.
Did all three kids grow up in the same home?
Yes,
And as they started to leave your home, did they stay in the same geographic area?
yes, we always used to stay in the same area.
Where did everybody live? Not street address, but just kind of give us a sense of it. I mean, we're all the way up in St. Augustine.
Well, my kids, they were born in different places. I moved, but once they started going to school, I became steady in a place. But, so for the last 30 years, we live in Florida, in the Altamont, Orlando area.
And did your children ultimately come to reside in that same area?
Yes, they did.
When did Jessie leave home?
Jessie left home after she graduated from high school, around 18, 19. That's when she met Michael Otto, and they left home. They came home and they lived with me for a little bit too. Talia was born under my roof.
And when was Elijah born?
And
How much further behind?
after that, they got their own place, and then that's when Elijah was born.
What's the age difference between the two grandkids?
They're only 10 months apart.
Now, she left and went away and ended up coming back to the same place where you lived in Central Florida. What about your other kids?
My other kids, they always, when they left, you mean when they left the home too?
Sure. I mean, help us figure out how close they were geographically and how they overlap.
We was always together, always grow. My kids we always keep in touch where they at. They change them, but always keep in touch with mommy. Always mommy know where they were all the time. Doing good or bad, they wanted mommy to know. Of course, they always keep their little secrets, even though mommy sometimes used to find out stuff, but we always kept in touch with me and with their sister. They were together. We went together to church, everything together as a family.
Would it be fair to say that they were incredibly close to one another?
Yes,
Would it be fair to say that they were friends with one another?
yes,
Would it be fair to say that they raised their families together?
yes,
Would it be fair to say that some of your younger kids had children because Jessie had children?
yeah.
Was it ultimately their goal to live their lives together for the rest of their lives?
Yes, we as a family, actually I was the first one that moved to Florida and from New York, and little by little all my family came here, mother, brother, sister, everybody. So we all stay together.
How big is your family here in Central Florida? I mean, how many people live in this area?
A lot, like, wow, about 100 of us.
There's about 100 of you in Central
Yeah.
Florida? Aunts, uncles, cousins?
Yes, uncle, cousin, nephews, grandkids.
Was Jasenia close to all of these people?
Yes,
Did you do things together as a family, all of you?
always. On Christmas, we used to get together when they were growing. It was like 50. When my dad was alive, we always used to celebrate Christmas together with all the grandkids, like 50 grandkids.
When did your parents pass?
My mom passed away 9 years ago. My father just passed away. It'll be a year next month.
Even after your mom passed, did all the grandkids still come to your father?
Yes,
Did everybody still celebrate the holidays together?
yes,
Did all the great-grandkids come too?
yes.
Jasenia's kids, what were their relationships like with the rest of the family?
Since I'm the youngest of my 6 brothers and sisters, the youngest and the first one that started having pretty much grandkids, they were very special to the family. They always used to enjoy having them around. They were very happy kids. Since I was the little one, they always cared for me. So always there for all of us.
And for your children and their children as well?
Yes.
Were the grandchildren always involved in the family gatherings and the events that were happening within the family?
Yes.
Did they feel loved and comforted when they were with the family?
Yes.
They feel like they had a place to go,
Yes.
a sense of belonging?
Yes.
The same applied to your daughter, Jasenia Suarez?
Yes.
During the time, October of 2013, was there anything going on in your family? Any great rift? Any problems that were occurring in the family? Any fights or divisive behavior by any of the family members?
Yes.
Okay, and what might those have been?
October when Jessie asked me that she was going to go on a job trip. And she said, "Mommy, can you watch the kids for me?" And I did ask her why can Louis watch them. She said, "No, I want you to watch." I said, "What's going on?" And she said, we're not doing that great, Mom." I said, "Okay, I'll watch them." So,
Well, before you go any further, aside from this problem that your daughter was having with her husband, were there any other problems in your family? Did she ever feel like she couldn't go to your family members and see them and ask for help? Did she ever feel that she wasn't loved? Did she ever feel like she didn't have a place where she belonged?
no, Jessie knew she could come to any of us, to any of my family, and told them their problem.
So there wasn't like this big fight or blow up that she had to escape from within your family?
No, Jessie would have never escaped from us. Jessie would have approached us and come to us or whatever.
How about the kids? Was there any reason for them to run away and leave their entire family behind?
No, my grandkids. No, they would never run away. The first place they would have run, it would have been to Grandma's house.
They would have come to you. That's a yes?
Yes,
In fact, you live just right around the corner.
yes, just around the corner from Jessie.
Where did you live? Is it related to her? How far away if you drive it?
2 minutes, not even. 7 houses down, just around the corner.
For an 8 and 9-year-old on a bike, they can ride their bikes there, right?
They can walk, yeah.
In fact, they rode their bikes there or walked there often, didn't they?
Yes, they did. Actually, we didn't let them walk by themselves. I used to meet them on the corner to watch him, not to leave him alone, just because what goes on in our world.
Did your daughter and her children visit your home often?
Yes, my grandkids were in my house every day.
Did you visit their home as well?
I did, even though I didn't like to go much over there. I prefer for them to come home.
Was your preference based upon your feelings for the defendant?
Yes,
Let's not make any mistake about this. You didn't particularly like him, did you?
no, I did not.
In fact, when they got married, it didn't make you happy.
No,
Was there a time that you thought he was good for the kids?
yeah,
Was there ever a time that you thought he was good for your daughter?
that's what my daughter wanted, so I had to accept it.
When did they get married?
2000, on New Year's Day, 2011, January 1st.
Did they live together before they were married?
Yes,
In which county or city did they live?
Orange County.
Was there a time that they lived in Seminole County, more specifically a time that they lived in Sanford?
Yes, they live in Seminole County too.
In 2013, they didn't live in Seminole County though, right?
No, they live in Volusia.
Is that the house that was just around the corner from you?
Yes,
But they had previously and just recently lived in Seminole, is that right?
yes,
In fact, which county did the kids go to school in?
Seminole.
How long had they lived in Seminole County?
Almost 2 years.
So
Almost 2 years, because as soon as they got together, that they used to live in Orange County, then they went and moved. They rented a home from my brother, and they moved to Seminole County.
Shortly after they met?
Pretty much, yes,
So in this 2-year dating window,
yes,
the defendant lived in Seminole County for 2 years.
yes,
And you know that, you visited him there.
yes.
I assume after they got married, they moved over to Deltona near you?
Yes,
Is that, okay. And how long did they live in that house?
2 years.
Of the 4 years that they had been together, though, they lived half their time in Seminole?
Yes,
You've told us a little bit about your daughter's connection to the family and your grandchildren's connection to the family. What I'd like to talk to you is about some of the things that your daughter did with her time, where she worked, where she went to school, the things that were going on in her life as we're coming closer to this 2013 date in October. Tell us a little bit about what was going on in your daughter's life, the important things that were happening for her.
my daughter, like I said, she always wanted the best for the family. So that's the reason she decided where he stay in the house while she worked and go to school and help her with the kids. Even though I always told her I couldn't watch the kids, but like I said, I respect her decisions. But there was days that Jesse wasn't happy because the things that were happening in the house.
Well, I don't even want to get there yet. I
Okay.
still want to stay focused on what she was doing with her time. Where did she work?
She worked, at one time she worked at Rollin College while she was going to school there. Then after that, she started working a K-9
American Canine?
American Canine. Yes, that's where he was working. She works during the day, and at night she used to go to school. That's when,
Every day?
every day,
So she worked every day during the day, and every
And
day
she
she
go to
went to night at school. Where was she going to school?
Raleigh College.
What was she working on as far as a degree?
I know it was something with HR and with administration.
Was it a bachelor's? Was it a
It was
master's?
a bachelor degree.
Okay, so she was working on going to college
Yeah.
at
yeah.
night school.
In high school, she did do enrollment.
No, night school.
I'm sorry, night school?
Night school.
Yeah,
She was
night
going to school at nights.
Yeah,
Okay.
at night, yes. She went to school at night, and that's where my help came, helping with the kids. And
How far along was she in her education at that point? In October of 13?
my daughter, she was so proud of herself that she was looking forward for that bachelor degree. Going back, I remember when she graduated from her associate, she didn't even want to go to her graduation. And I'm glad she did win, because I saw her with her gown. Because she used to say, "Mommy, soon I'll be wearing my gown with my bachelor degree." But that time never came.
Was that something she was proud of?
Yes,
How much did it mean to her?
a lot. Because for her, that was her life, and for her kids, for a better future. Yes, he always wanted for me and for the family, to be proud of her for everything that she did.
How close was she to achieving that bachelor degree?
In May, she would have graduated, no, December. In December, she would have graduated her bachelor degree,
December of 13 or 14?
13.
So just a few months
Yes.
from graduating. Was she doing well in school at that point?
And
Was she excited that she would graduate?
yes, he was cum laude.
Cum laude?
Yes. She was very proud of everything she was accomplishing. So do I. That's the reason she always wanted the best for the kids. And since she was little, Jessie could never get a C, because if she got a C, she cried. It's either A or B was okay, 1 or 2 B, but that's it.
How many years did she work towards this goal of graduating and getting her bachelor's degree?
It took her a little bit, just because in the beginning, when she had the kids, So the bachelor, which I think was like 6 years that it was taking Jessie a little bit. I remember telling her, "Jessie, it's okay. If you be done by 30, that's okay." But 30 never came.
Yes, sir. If I may finish with the schooling stuff. Okay. Was her schooling something she would have abandoned ever?
No.
When graduation occurred in December and she wasn't there, was there still a ceremony?
Yes, Raleigh College did a ceremony and gave me my daughter's diploma.
Did you walk across the stage for her?
Yes, I did.
Was your family there?
Yes.
We can probably stop now, Judge. Yeah, we can probably stop now.
All right. Okay. Ladies and gentlemen, we're going to take our lunch break at this time. maybe until 1:30. I want to remind you, please don't talk about the case with anyone or among yourselves. Don't do any research of any kind while you're away from the courtroom. Don't look up any words or maps or use your phone or the internet or any device to find out anything about the case. You're welcome to go to lunch together if you want to be together, but don't talk about the case, all right? See you back at 1:30 in that jury lounge at the end of the hallway.
That was early testimony in the Luis Toledo case out of Florida, and that was the mother of the wife who the state is saying was a victim of murder in this particular case. Yesenia Suarez, 28 years old, said to have been killed by her husband after he caught her having an affair with a coworker. The state is also saying that the defendant, Luis Toledo, ultimately killed the two children that his wife had had with yet another person, ages 9 and 8. Now, what's interesting here, Josh, is that this mother of the victim, who we just replayed her testimony, is the one who set the whole investigation into a spin.
Yes.
She's the one that started it. So she starts out calling the police saying, hey, look, my daughter's been having trouble with her marriage. I've been trying to get a hold of her this morning, and I can't get a hold of her. So they immediately go running over to do a welfare check, and nowhere to be seen. Mm-hmm. Now, I'm starting to look through some of the original case documents here. Apparently, the defendant had claimed to police when they made contact with him at the home. His original version of events was that at about 11 o'clock the night before, because of this trouble they were having, keep in mind on the 22nd of October, 2013, he confronts her at work, shows up at her job, confronts her, they call the police, he hightails it out of there before the police show up. Now, he claims that night he didn't get home until 11 o'clock, and that he slept in his car in the parking lot until about 8 o'clock. That's his version of things. Well, that's directly contradicted by the neighbor who says, no, at about 6 a.m., the defendant asked me for help, so I drove his car up to this other county, okay, and saw him wiping down his wife's car. Okay, keep in mind that the daughter's blood was found in the trunk mat of the wife's car later. And then after being part of this cleanup operation, the two drive back. The defendant tells the neighbor, quote, I snapped. And at one point they stop at this dumpster or some kind of a trash bin and throw the kids' toys in it. The neighbor goes and tells police about this trash throwing expedition. The police recover all the kids' toys, and we saw within the last couple of days just these garbage bags full of those little kids' toys being paraded out in court. So that's the defendant's original version of things. It just doesn't add up.
Right.
It doesn't add up for this defendant.
Clearly he had to change stories at some point, and it seems he did. You know, when under what you and I were talking about was a very extensive questioning while in custody. He went with a very different version of what happened, in which he admitted that he had snapped and he karate chopped his wife in the neck, I believe is how he described how he killed her. But in any event, there was no question he was there that night. He's the one who killed his wife, and then he switched tactics to merely denying that he was the one who killed the children. So yeah, no, from day one, his stories have not been adding up, it seems, and I imagine that's something that the prosecution will point to, even as they utilize his own statement against him with respect to his wife. His denial of having anything to do with the killing of the children. I think the fact that he was lying from the get-go won't help him as he tries to be believed that he's telling you the truth about this, about the wife and the children. I think that's simply not believable. In addition, he blamed the death of the children on the neighbor, Mr. Jackson, the one who helped him dispose of all these things. And Mr. Jackson was confronted with that when he was on the stand. and apparently broke down crying at the idea that he could have possibly killed the children. I have no idea what possible motivation the defendant could have put forth for why his neighbor would have killed the children, but apparently that's what he claimed, and that at least at some point in his questioning, and I don't know where it was, he tried to pin it on the neighbor, you know, I think it's things like that that might spell a guilty verdict, even with respect to the children, because there's simply, even without his own confession, there's no reasonable explanation for what happened to the children.
There isn't, and this is exactly what came up in court yesterday afternoon. And our senior trial producer, Kathy Russin, was transcribing the list of, there were originally about 15 points that the state really wanted to go through to counteract this defense assertion that, hey, look, you don't have bodies, you can't prove that there was a murder. Well, the state came back with this, and this is not the exhaustive list, but this is most of it. No contact from the victims, either the wife or the two children, since basically 1:03 a.m. on October 23rd, 2013. Okay? They've disappeared off the face of the earth. No activity in the wife's bank account. The children never returned to school after the 22nd or whatever the preceding day was. I'm not sure if the 22nd was a weekend day or not. But they didn't show up in school on the 23rd. They've never been back. Okay. The wife had a good job. The wife was just months away from graduating with a bachelor's degree, which we just heard the wife's mother testify about. It was a big deal to her. Okay. Her car was left behind with her purse, checkbook, and cell phone inside it. Left the whole house of possessions behind. The testimony from another neighbor who heard screams saying of a woman saying, "Help me," that night. Now, that's just one of those cringeworthy things where the neighbor started to look around a little bit outside, but didn't see anybody outside and just sort of assumed it was kids screwing around. But in hindsight, it was probably Yesenia Suarez being attacked. Just another horrible circumstance in this case. But we've got that. The investigators find blood in the bathroom that matched Thalia Otto. Not only just in the bathroom, but also in the trunk mat, okay, of the wife's car. Now, it'd be one thing if it was like on a door handle or something like that, but the trunk mat would suggest that a body was put on the trunk mat.
I believe it was also on his boots.
On his boot, yes. So, and his boot print was in the back of the car too. So we had that evidence yesterday. Okay, so you've got the 9-year-old daughter's blood in the bathroom. Okay, well, I mean, she lived there. That makes sense. Okay. But then on the boot and in the trunk mat, now that doesn't make any logical sense, but for that she was murdered. Okay.
I believe they also said it was something like 15 drops of blood, which if they were all, let's say there were 15 drops of blood in the bathroom, that's a lot of blood. Even if she's, I don't know what she's doing that would cause there to be blood, but you know, a tiny bit, maybe 15 drops of blood, something happened, you know, so either way, you know, it's, again,
it
but
doesn't look good.
It isn't just there, it's all over the place.
It is all over the place. Okay, and then one of the other points that the state made is that the kids are too young to be independent. Now, look, I understand that the defendant has a right to present a defense, a vigorous one. That's being done here. But this is a case where if I were sitting there listening to all this, I would say, you know, it does bug me that we don't know the whole story. It bothers me that there are spots. But come on, I would have to vote guilty based on what I know here. This is not just a case where we're trying to line up cell records to see if someone was really in a place where, you know, they knew someone who then encountered some foul harm. This is just adding up to be way too much.
Oh yeah, yeah. You know, I'm wondering why the defendant has persisted in his in this line of defense. The idea that, I mean, it's possible that without counsel, he simply admitted to having killed the wife, wasn't able at that moment to admit that he had actually killed the children too. And so left with that position, a defense attorney simply said, well, we'll play the hand that we have, which is a terrible hand nonetheless, but that is the hand that they're trying to play. I mean, to me, it's worth considering why you wouldn't simply acknowledge that you did indeed kill the wife, you did indeed kill the children, and offer some explanation for how this might have happened. Something short of, it was my premeditated plan to kill these 9 and 7-year-old children, if I have the 9 and 8-year-old children, 9 and 8-year-old children, to cover up the murder of my wife, which is frankly about as ruthless and despicable as you can get. And I don't think any juror would have trouble voting for the death penalty in that case. So, maybe it's simply, maybe the answer is he doesn't have a good explanation for, and maybe that's exactly how it happened. And you can't simply tell a jury that will not help. You won't escape the death penalty by admitting to that. And so this is what they're trying to do then, is find their way out any way they can. But these ideas as to what happened to the children that at least the defendant threw out at different points don't seem to be helping him. I wouldn't think, at least.
They don't make any sense in corroboration with, or an attempted corroboration with everything else he said. It just doesn't line up.
No.
I mean, he can't be sleeping in the parking lot and then later be admitting to karate chopping his wife in the throat. And again, we don't even know if that's fully the cause of death. Was that just part of it?
Right.
Was it made up? Was it even true?
Right. I mean,
did he try to admit to something really bad, thinking, oh, well, the only thing they can get me on is assault and battery? I mean, come on. I don't know what's going through this guy's mind.
It's certainly possible that, yeah, he tried to portray it at that moment in his own mind. He thought, perhaps I didn't mean to kill her. I karate chopped her in the throat, but I didn't mean to kill her. And then when confronted with the death of the children, well, he simply can't admit to anything with respect to that, because there's just no explanation that he could come up with quickly enough that would make him anything other than a ruthless murderer. So he admitted what he thought would be the least damaging evidence possible, which is, I karate chopped her in the throat, and I guess inadvertently killed her by doing that.
I don't know. Well, look, in every case like this, there is an attempt by the defense to get certain things excluded. The standard motions in limine, the suppression motions to suppress pieces of evidence. Oftentimes they reveal little nuggets. They're mechanical. I give due respect to those who write them out and pound them out on a daily basis, yourself included. Because the minutiae is just not the way my mind works, or I chose not to make a career doing it, at least at this point. Every once in a while I get little nuggets out of seeing them, though, and this one I think is interesting. In one of the suppression motions, it turns out that he was interrogated countless times. There was an interrogation on the 23rd, okay, so the day of, for 3 hours and 21 minutes. He was interrogated the next day, the 24th, for 10 hours, 15 minutes. That's a long interrogation. On the 26th, 22 minutes. There was another interrogation on the 28th, another interrogation on top of that on the 28th, that was 1 minute shy of 4 hours. Another interrogation on the 29th, and another one on November 2nd. And it says here, this is defense arguing this, that the defendant was interrogated for 13 hours, 36 minutes just in the first 24 hours of his custody, beginning at 4 p.m. on October 23rd. I'm counting at least 7 interrogations here. That's a lot of interrogating. Yes. No wonder they're fighting so much about these statements to police, because it's not just one interrogation or 2.
Right.
This is at least 7, and the one is 10 hours and 15 minutes long.
What I hadn't realized till now is that they spread over a week, more than a week, and
October 23rd through November 2nd.
What's unclear to me is, at what point in this process was he formally charged? And at least and now I have to admit my ignorance of Florida law, but at least in New York State, when you're charged, you're giving counsel. There's not going to be any further interrogations without counsel. So I don't know what happened here, that maybe he was in custody, but they didn't charge him and they released him again, then brought him back. You know, this would be much more
this all
common.
says the sentence right before this is interrogated in custody.
Right,
Because,
I
look,
heard you say that.
For those watching along with us here, we're starting to engage in a bit of a lawyer's debate here, but those magic phrases, custodial interrogation, that's when Miranda attaches. Maybe he waived.
And yet, and this is what's interesting. It's possible that what the lawyer means by in custody is that he was brought down to the station. All the elements of a custodial interrogation were there, but he wasn't charged and he was released. And then he was asked if he would come back again and again. Now that can happen sometimes, that police will engage in multiple interviews. They would call it an interview. A defense attorney would call it an interrogation. But what I'm not familiar with is any situation in which a defendant would be arrested, would be held in custody, would be questioned for, let's say, 24 hours, and then no charges brought, and he simply remains in custody. Unless, of course, he's in custody on some other charge, you know.
Well, that's what they're trying to do. They were trying to book him on this incident. I believe, if I'm reading the document correctly, the incident from the workplace. Even though, and this is what the defense is arguing here, even though there isn't an active warrant out for it.
I see.
So some of the back and forth here is, wait a minute, you got this guy and you think you've got him on something, but you're grinding your wheels, and yet you're still locking him up because you don't want to let him go.
Right.
Usually they try to find him on something. And I guess that something in this case was the incident at the workplace. But then again, okay, well, he's not charged with that incident today.
Yeah. To say that those two incidents are not related is also, frankly, a little difficult to actually, say with a straight face. If you're investigating the incident at the workplace, and now you're asking him questions, well, I guess the prosecutors might say the police simply didn't ask him questions about what happened at the workplace, because that's why they had already determined probable cause and had arrested him on that. And now they were questioning him about other unrelated crimes, or that's what they would argue, I guess, unrelated.
Yeah, they were trying to go after him for a domestic violence thing on the 22nd, and they were probing at his knowledge with the caveat, help us find your wife, we don't know where she is. Apparently that's how they got him. They arrested him on the 23rd, and at no point was he let go.
And they kept bringing him back over to the police station or somewhere in the jail.
Well, no, he was incarcerated. Yeah, I mean, they locked him up on the domestic violence.
Yeah.
Apparently, that was the initial thing, even though that's not part of the charges that he faces in the instant case.
Right. And they kept continuing to question him. Well, frankly, I think the defense actually does have a reasonable argument here. There are different states handle this question differently. This is one of those lawyer areas, in that the Constitution prohibits certain kinds of interrogation, and that's announced by our Supreme Court. They're the ones who tell us not only do you need to give Miranda warnings, but a custodial interrogation would include all interrogations where a defendant is in custody, even if on another charge. Now, that is not the rule of the Supreme Court, but that happens to be the rule in some states where basically they don't want to even let this kind of funny drawing of lines go on, because they're concerned about just this kind of behavior, I think, by police, in which a defendant is in custody, so he's naturally under duress, is the theory, and when they say to him, you're free not to speak to us, he doesn't really feel that he's free not to speak to them. He's in custody already. And so, I know it seems the defense lost their suppression motions pre-trial. This statement is coming in, but that's obviously an issue that they'll have for appeal, and I imagine they already have to think about that because it seems quite clear that this defendant is most likely going to be convicted. Apparently, the issue that they were dealing with this morning with the statement I was just reading was that there was some portion of the statement in which the defendant referred to one of the victim's cousins as a lesbian. Some offhand comment about, oh, her lesbian cousin. That's what I was reading. And that the defense wanted that portion redacted as well because they felt that it portrayed the defendant in a bad light. It made him seem insensitive or biased in some way, anti-gay, essentially. And so the fight, I guess, was the defense felt that that was a portion that I think they believed already had been agreed to be redacted. The prosecution said, no, I don't remember ever agreeing to such a redaction, and the whole thing broke down over that statement as well. And again, it just goes to more evidence. The defense is there to try and keep things from looking, from all the evidence making this defendant look like a monster, a disreputable, heinous person. And frankly, you know, a small comment like what he said about the victim's cousin, I don't know that it really matters, but I guess they're doing their job to try and stop any outside, you know, any and all possible sources of evidence from which the jury could infer that this defendant is a bad guy, basically.
Well, we're going to continue reviewing some of the previous testimony in the case. One of the critical witnesses here, the neighbor who ultimately said, hey, look, this guy, the defendant, Luis Toledo, asked me to take his car, meet him. He was cleaning off his wife's car, and then on the way back said he snapped, and on the way back we stopped and threw the kids' toys out in a dumpster or some kind of a trash receptacle. Critical testimony. Let's review it again now.
Develop a relationship with Mr. Toledo and the children who live next door.
This like around the summer of 2013 when I started going to barbering school.
He went to barber school too, right?
Yes, sir.
Did he go to barber school before you did?
Yes, he did.
Was that a large part of the reason that you went to barber school?
Yes, sir.
Before you started going to barber school, had you ever spent any time with that man?
No, sir.
How long had you lived in your home at that point?
I want to say like at least 6 or 7 years.
And how long had he lived there, next door?
At least like 2 or 3 years already.
Okay. Did you ever talk to him?
Not really.
Describe your relationship prior to barber school.
Just like hi, bye, and pretty much that's it. Just saying hi to him.
Were you the kind of neighbor that would wave when you go to the mailbox?
Yeah, not all the time. I'll say hi when somebody like says it to me.
Anything more sophisticated or more entailed than just hi and bye and waving occasionally?
No, sir.
Would you call him a friend at that point?
Not at that moment.
What did you do after school, typically? What were some of the things that you did?
If I didn't have to go to work, I would like record music.
What kind of music?
Mostly hip hop.
Do you have a mixing studio in your house that you use for friends?
Yes, sir.
Do you have a girlfriend?
Yes, sir.
How long had you been together with your girlfriend?
Probably about a month prior.
What was her name?
Courtney.
You still with Courtney?
Yes, sir.
She's the mother of your children?
Yes, sir.
Now, at this point in your life, you had gotten into a little bit of trouble, right?
Yes.
Okay, why don't you tell us about that?
I'll say probably a month prior, I had the police come to my house. They came and did a search warrant of my house and found marijuana at my house.
Did you get convicted at some point of a burglary as well?
Yes, sir.
Okay, tell us about the burglary, please.
It was probably almost the summer of 2012. I was in my senior year. Pretty much the problem was coming up, and my mom was working pretty hard, and I didn't want to ask her for like money for prom and stuff, so I took it upon myself to go figure out a way to get it. So I was stooping and young pretty much and tried to figure out a way to get it without asking my mom and burglarize the school.
What'd you do?
We were trying to take some computers.
Do you regret doing that?
Yes, sir.
Has it made it difficult to find work in your life since then?
Yeah, pretty hard, honestly. I got.
In October of 2013, were you still on probation for this offense?
Yes, sir.
Do you remember your cell phone in October of 2013? What number it was?
I don't remember the number by heart.
If I read you a number, do you think you'd recognize it?
Yeah.
386-960-3604?
Yes.
Was that your number?
Yes.
Was your mom's telephone number 407-272-3105?
Yes.
Now, you've already told us that the defendant lived next door.
Yes, sir.
You see him here in the courtroom today?
Yes.
Could you point him out? Tell us what he's wearing, please.
He's wearing black with glasses and a jacket.
Was he married at the time that he lived next door?
Yes, sir.
Did his wife have children?
Yes, sir.
How old were the kids?
Like around 6 or 7.
Was there a large age gap between you and the defendant?
Yes.
Was his life very different than yours?
Yes.
Was it enrolling in barber college that really allowed you to get to know the defendant?
Yes, sir.
Tell us how you came to know him over that time.
Pretty much he'll take me to school every day, and we have classes together, so we got to talk more.
Did you have a car at that time?
Me? No.
So really, he was your way to improve your life.
Yes, sir.
Did you spend time together in your classes? I know you said you had classes together.
Yes, sir.
Did you study together?
Yes, sir.
Do you know the name Robin Roberts?
Yes.
How do you know Robin Roberts?
I'm from school.
Was she also a good friend and confidant to you?
Yes.
When school would end in the afternoons, did you and the defendant go straight home?
Yes, most of the time.
Did you end up spending some time at his house?
Yes.
Tell us some of the things that you would do with him.
Pretty much just play video games.
Were the children there?
Yes.
What'd you do with the children?
Sometimes I play basketball with the kids or help them with homework, help Toledo, like, do backflips and stuff for her because she wanted to learn how to do backflips for cheerleading. And, pretty much that's pretty much about it.
Did you like the kids?
Yeah.
Do you have anything to do with their death?
No.
Keep going.
Did you ever spend time with the defendant's wife, Jasenia?
No.
Do you have anything to do with her death?
No.
What time did Jasenia usually come home with her husband?
At times.
What was she typically upset about?
Just like normal stuff around the house, like laundry, kids' homework, just normal stuff.
Was it arguments? Was it fist fights? Give us an idea.
I didn't see any fist fights, but I know there's arguments.
Did she have really high standards?
Yes.
I'm sorry. Sustain, can you rephrase the question?
Sure. Did she want her kids' grades to be perfect?
Pretty much, yes.
Did
She
she
expect the high of them, yes.
Okay. Did she want the house to be very clean?
Yes, she's very cleanly.
Did she want laundry folded and dinner cooked?
Yes, from what I've seen.
Did the defendant ever talk to you about his marital problems or arguments that he'd have with his wife?
Occasionally, we never got too deep into it.
Was it clear to you that he didn't feel appreciated for the things he did around the home?
A little bit. He complained about it.
Did you become aware at some point that they were going to have a divorce or that they were getting divorced?
Oh, yes, towards the end. Last couple of days in school, I seen him. He spoke about it.
Was school ending in October? You say it was towards the end of the school.
Before he stopped going, before all this trial stuff happened.
In October of 2013, did the defendant change fields from barber to HVAC air conditioning?
Yes, sir.
Did he ever tell you why he did that?
Pretty much because of money and more stable. Like, it feels a little more stable.
Could he still attend the same school and attend the HVAC classes or the air conditioning classes?
Yes, it's the same school.
Did you continue to ride with him during that period of time?
No, our schedule was conflicted. It's different scheduling.
How far in advance of these murders on October 23rd, 2013, did the defendant change his field?
That was the neighbor who testified that he helped the defendant basically try to cover up a crime. The neighbor was so suspicious of what was going on that he flagged the police almost immediately. So, Josh, you've listened to a lot of that testimony. Do we take him at his word? Do you think he's credible?
I think he's credible. Yeah, it's, you know, he certainly, there are issues with his credibility in the fact that he's admitted that he was helping someone cover up a crime. And so his own culpability definitely colors the credibility of his statement.
Is. And he said the conversation on the way back was just incredibly weird. Silence except for this statement from the defendant, according to the neighbor, where he says, "I snapped."
Right.
So, I mean, talk about a weird situation he was thrust into. He immediately tells the police, okay. And then, you know, the defendant attempts to discredit him and say, no, he's the one that really killed the children.
Yeah.
And
yeah.
I think that his response to it was credible, just saying it was basically a no. He just got swept up into this thing.
Yeah, it seems, you know, I would say it seems as if he's a guy who found himself in a really bad position and is telling this jury what he knows, you know, which again, he doesn't know what happened. So it's, you know, it doesn't seem like he's trying to overextend his testimony. He's not trying to claim more than he could reasonably claim. He simply seems like he's saying, this is what I observed, this is what I was involved in, and for what it's worth, this is what it may or may not say about the guilt of the neighbor. I think he's a good witness for the prosecution in that instance. So, yeah, I don't know what we're moving to next, but
I was probably going to switch into some of the testimony of the lover because he was on the stand for quite a while, and you know. We can keep belaboring the points here, but if I were on the jury, I would have to vote guilty on this. I might have a hard time reaching the premeditation charges on the children, but I'm pretty convinced that he did it, personally, just based on what I know now.
Right.
There are just too many inconsistencies in his story. There are too many other things going on. The law enforcement investigation sounds like it had its issues. You know, they originally picked him up because there are two different departments. There's a local police department and a sheriff's department. And they're sort of back and forth. One was investigating the domestic violence from the day before, the 22nd. There was a report of domestic violence, and the local folks said that there probably was enough evidence to arrest him, but there was not a bulletin, not a warrant. There was nothing where they actually wanted to take action on it. Mm-hmm. Okay. And you've got the other department starting to look into the disappearance because there's the call from the wife's mother,
right,
saying, I can't get a hold of my daughter. She's had some trouble in her marriage. I've known about it, and now suddenly I can't get a hold of her and the kids aren't at school. So then the other department starts investigating that, and there's back and forth between these two departments. And like, well, let's pick them up on this domestic violence. The defense is waving its red flag and saying, no, wait a minute, you can't just go pick them up on it without the warrant, which...
Well, sure you could.
Yeah, you're getting into semantics there. I think
mean,
the defense has got a losing argument, but they're trying to make it.
I was going to say, I mean, under most states, if you have probable cause, you can
You
pick
can
them
make
up.
an arrest, yeah.
Yeah.
Now, what's interesting about it is that I think that in some of the reporting of it, there's been a whitewashing, perhaps, of just how on the ball this law enforcement investigation was. Because at first blush, it sounds great to say, oh yeah, we already had him on this other thing, so then we'll take a couple months to put together our murder case and then charge him on that, because they didn't charge him on the murder until the following year. Okay, so it's early 2014 before they hit that.
Right.
At the defendant. They throw those charges at the defendant, and those are the ones we're talking about on trial right now. But part of me wonders, and maybe I'm wrong for thinking this, but part of me wonders, hey, look, if you'd picked them up on the domestic violence right away, wouldn't you be here having this discussion about this murder case? If the local cop thought that there was enough to get him on the domestic violence on the 22nd, why was stuff still going on the 23rd?
Yeah. I wonder, though, in fairness to the police in this instance, whether whatever he picked him up on the 22nd, let's say they did go ahead and pick him up on those charges, I don't even know that they were serious enough to have him held on any significant bail at that time, because, again, it would be routine practice to issue, for the court to issue an order of protection while he's out on his own recognizance or out on bail. And that order of protection would have said that he couldn't go to the home, he couldn't be in contact with his wife. Though my suspicion is, in this instance, if he was willing to kill her, an order of protection, a piece of paper, wasn't going to stop him anyway. So I don't, I guess I don't want to blame the cop who didn't make an arrest for the death of this woman, because I'm not sure it would have stopped it from happening anyway.
Ultimately, the blame in the strict sense is on the person who did it.
Of course.
And we're assuming guilt here, even though there's a presumption of innocence.
Yes.
But it's just one of those things where when we start looking at systems, people turning around saying, hey, wait a minute, what's up with this? And, look, it's a matter of court record that's the way this thing sort of transpired here.
Right.
Now, I think it's interesting that ultimately this domestic violence charge at least seems to just have been floating out there. They pick him up on it. What did they do? Did they toss it and just say, well, we think we're going to get you on this murder? We no longer have a witness or a victim to testify on the domestic violence. So did that charge just sort of vanish and in theory, I guess, was replaced, although legally that's not the way it was done with the murder charges.
Right. I would assume they simply dismissed that other charge. Or it's still sitting and it's second in line. There have been instances like that where, God forbid, the prosecution is not able to make their case on a murder. And this would be an extreme example of it, but they want to move forward on the most serious charge first, and there still is potentially, I guess there's nothing that precludes them from, if they lose this case, then trying him on some, what for all I know may even be a misdemeanor domestic violence charge, if they think they have the evidence to prove it, because perhaps there were other witnesses who they could rely on. My suspicion is we're not going to learn. We're not going to learn whether that will happen, because there's not likely to be a not guilty verdict here.
It doesn't seem it the way things are going now. I mean, I would hate to be the defense attorney in this case, because I think that the defense is trying to play a horrible hand of cards.
It seems if that statement from the defendant stays in, they're stuck in a very, very difficult place in terms of defending. And while we were watching that last clip, I also went back and reviewed the law that I knew about, because it did occur to me that something about that behavior of police officers arresting a suspect, holding him on one charge, and then continuing to interrogate him on seemingly, or even if fully unrelated charges, something about that struck me as wrong, and it was that in the state of New York, at least, that's not permissible. That in the state of New York, and it's not because of the Fifth Amendment Miranda right, it's actually your Sixth Amendment right to counsel. In the state of New York, once you're arrested and charged with a crime, your right to counsel attaches, and you now have an attorney. without that attorney being there, you can't waive your other rights. You couldn't agree to speak to the police, even about some unrelated charge, outside the presence of your attorney. And any attorney would never let you do that. So under New York state law, this couldn't go on, as I understand the sequence of events here. But
that's a new one on me. I don't have a law license in New York, but as we say, the federal Constitution provides a floor of rights, and many states do extra rights.
Absolutely.
This one will probably shock you if we want to get into side discussions, because we have a little bit of time for it today. In New Hampshire, where I have one of my law licenses, there is no automobile exception to the warrant requirement.
It just simply doesn't exist.
Yeah, it doesn't exist. And the Supreme Court says you have a zone of privacy in your vehicle. You know, what's the constitutional language? Houses, papers, persons, and effects. They turn around and say
vehicle.
Includes a vehicle. Now in New York, your car can get searched without a warrant, exigency.
Yes.
You could be making off with some criminal item. So, you know, different states provide higher or heightened levels of rights in some of these different areas.
Yeah.
So
the automobile exception has always been one of those exceptions that was so large you could basically drive almost all of
an automobile through it.
Yes, exactly. I mean, it's huge, and the rationale behind it, other than the exigency, which they always pointed to, that if you don't search now, the car can be moved. It's a vehicle; it can move, which frankly doesn't really hold a lot of truth nowadays, when all you need to get a warrant is to call. Yeah, warrants can be obtained over the telephone. Mm-hmm. So the idea that there's some exigency need to go without a warrant, I find very not compelling. The other one that they always pointed to was that you didn't have the same kind of expectation of privacy in your car because it's open. There's windows all around it, right? And people can look in. Now that is true. People can look in, but they can't really look in all the places in your vehicle. So I don't think it's also that honest to say that you don't expect privacy in what you have in the glove box, in what you have under the seat, you know, in a multitude of places that nobody could actually see unless they open up your doors and look in your car. So, you know, frankly, as a you know, someone who believes in liberties, I think I like when states like New Hampshire decide that the automobile exception is simply not something that they're going to have in their own jurisprudence, despite what the Supreme Court decided. Yeah,
you know, other things, you know, the so-called community caretaking exception is another one that New Hampshire courts, they talk about it, but they're extremely hesitant to actually apply it. Because look, a lot of people presume, hey, look, if it's in my car, the cops can't just come and start rummaging around in it. And there are many cases where warrants were not obtained expeditiously enough, where people walked and said, hey, look, it took you too long to even get to the judge to get the warrant. Case dismissed. And it's different, but we digress. So
yes.
As to the Luis Toledo case in Florida here, one of the big pieces of testimony here was the wife's lover. You know, he's up on the stand talking about just the difficulty in the marriage, and ultimately he was the last one that talked with her. That was the 1:03 a.m. phone call on October 23rd, 2013. It was a 14-minute and 13-second call. He says that she sounded stressed and her speech was slurred. Now, part of me wonders, and I'm not an expert in the vocal cord area, but could the slurring speech have been the result of the karate chop, or was the karate chop after 1:03 a.m.?
What exactly? You know, I'm not familiar with the full details of what he claimed she said to him during that conversation. But one would imagine if he had already karate chopped her in the throat, she would have said something like that on the phone, I would think.
It's possible.
Yeah. Though it's also possible that the defendant was standing right there and was threatening her, which is why she sounded scared, I believe he said.
Stressed.
Stressed.
The testimony was stressed. And that she had slurred speech.
I know he was asked, I believe, whether he was asked whether he was aware that she took any medication or had been drinking or had done anything else that would result in slurred speech. You know, my guess is it was simply part of the stress. She was simply so frightened of what was going on that, you know, that it actually even affected her ability to speak clearly. and it came out as, at least on his end, as slurred. Though perhaps that's not the best adjective he could have chosen.
I mean, it's really unclear here. We don't have a body, so we don't have an autopsy. We don't know what the cause of death was. Of course, the defense still claiming that there's no body, therefore she may still be alive somewhere, which, based on the other evidence, doesn't make a lot of sense, but certainly they can try to argue it.
No, but that probably, you know, it's funny, we pass over that relatively quickly, and yet I imagine when they go back into the jury room to deliberate, that's the thing that I imagine someone in that jury room will get caught up, will get hung up on that idea. It will be hard for somebody because of the fear that they could possibly be making a mistake here, that there is no murder at all, and they're going to vote to send a man to prison and possibly the death sentence, and that at some point down the road, this woman and her children will walk out of the woods somewhere in Montana, for all we know, and will all look incredibly foolish, and that these jurors will have it on their hands. I bet that someone in that jury room will have trouble with that. I don't know how they get over it. I imagine that's part of the deliberation process. I would hope with the state's
list that we talked about before, all the different things, her bank account hasn't been touched, her purse, her phone, her car.
Right.
The kids' toys, all of the items in the house, everything was left. I mean, how would she have run away? Where would she have gone?
I know.
She didn't take any money. There's no evidence of any money missing. So I would hope that the state's going to make a strong closing argument on that respect. But we're going to listen to a little bit more of the lover's testimony, and we'll be back with more analysis in a little bit.
Did you know Yesenia Suarez?
Did I know her?
Yes. And how long did you work with Ms. Suarez at American Canine?
I worked with her corporate-wise for, I guess, just over a year. Yeah.
What were her essential duties within the company as you understood them?
As I understood it, she was responsible for HR deliverables. She's the one that would be contacting the employee, doing their pre-hire documentation, and onboarding, scheduling the briefings with various departments, and then pass them over to operations, so the operation department can then make sure all the training is complete, and then move from there. So all the way up to the hiring as well.
And how did that dovetail with your assignment at American Canine? Tell us kind of how that transition went as an employee moved through to your area.
Yeah, I was a deployment manager, so I was responsible for identifying a manning shortfall or projection and working with Yesenia on telling her that, hey, I need a guy or a handler or a person, a kennel master for this contract. She would then work with recruiting. Recruiting would give her the name of the person, and then she would make contact, do their orientation, send out the employee agreements, and make sure all that's done prior to them flying to training. So I would work with her in relation to making contact and saying we need to backfill a position. Or
was she essentially your direct contact or a conduit through which you acquired new assets for deployment overseas or into the line of duty?
Correct.
Okay. How much contact do you believe that you had with her while on the job during the period that you worked together?
Well, it was a daily thing where we always would communicate. I think very seldomly would we not communicate.
Okay. And I just want to be clear that in 2013 you were working in the Lake Mary office, is that correct?
Yes.
Okay. Did you have personal contact as well as electronic or telephonic communication?
Yes.
How much time did you spend with Yesenia Suarez in a social capacity, away from work, Christmas parties, that kind of thing?
Yeah, well, we had the first one would be the Christmas party, and I had
just, it wasn't much of interaction, but it was at the Christmas party. And then afterwards, we all went out to dinner. Well, not all, but some people went out to dinner.
Did you have an opportunity to meet her family, or more specifically her husband, Luis Toledo, during these social interactions?
Yeah, the first time I met him was at the Christmas party.
Okay. And do you see him here in the courtroom today?
I do.
Could you point him out, tell us who he's wearing, please?
Yeah, the man in a black suit, glasses.